Right. The judgment. In this matter, which has a long history, procedural history, counsel for the state outlined the progress with regard to various appeals. The decisions of the appellate courts are outstanding. That in itself justifies an adjournment of this matter to an appropriate date when the decisions of the appellate courts would become available. It is suggested that April or May might be possible dates for that, for those decisions to be available. However, there's another more troublesome issue, and that is the absence of Mr. Zuma from attendance in this court. It is common cause that he was warned to appear today, and it is also noted that he is not in attendance, and so the jurisdictional requirements of Section 170 of the Criminal Procedure Act have been satisfied. The question is whether his attendance or his non-attendance should be excused. Counsel for Mr. Zuma, Mr. Mancha, suggests or submits that he should be excused because he is currently receiving medical treatment outside the country. In support of this, or in an attempt to support his submission that Mr. Zuma is unwell and in need of medical attention, he submitted Exhibit 2/4/2/20. This is a document titled Medical Confidential, and in brackets is marked Pharmacy Copy. It bears an original stamp of the military hospital without any date attached to the stamp. Furthermore, the Section B of this form uses an abbreviation HCP, which has no explanation on the form, and Mr. Mancha was unable to help the court with an explanation. Below that is written or typed as part of the form, layman's diagnosis in brackets with consent of patient, close brackets, and in handwriting appears the words medical condition. That too does not elucidate what Mr. Zuma's condition is. In fact, it is puzzling that there is a reference to a layman's diagnosis, and what the patient's consent is quite unclear. There is also apparent from the form in the section relating to the date of sick leave, the date is altered to be January 6th. There's no initialing of that date. It is not clear that Z.K. Moteni, who apparently signed this document, is indeed a registered medical practitioner. Mr. Mancha submits that the numbers appearing above his name would be his medical practice number. That might well be the case. However, that is guesswork. Mr. Mancha is assuming that, and the court does not have it as evidence or reliable evidence of the status of the person signing this purportedly signing this Exhibit 2. So the court accepts that Mr. Zuma might well be unwell. There is nothing to suggest that he is or is not. Now, in this regard, what goes out in the public domain, in the media, and what is exchanged between counsel is not evidence. What this court requires is evidence, some authentic, reliable proof that Mr. Zuma is indeed ill and when he will be available to stand trial. Not only is that evidence necessary to determine his availability to appear again, but also it's necessary to determine how the trial will be conducted, what interruptions might be expected, if any, during the trial, what accommodations and arrangements might need to be made for him. Now, none of that is before this court. None of that helps the court to administratively prepare itself for what will be a very important trial. It is also the duty of this court to ensure that everyone is treated equally under and before the law. I mentioned that yesterday I had to issue a warrant of arrest for a person who did not appear in court, who had, after being warned of the need for a medical certificate, chose not to produce one. Those persons are in this court. The comparison between this and anyone else, particular representatives for accused 2, is not the only comparison. The comparison that the community will make is how does a court treat Mr. Zuma in relation to everyone else. And so it is standard practice in this court and in every court hearing a criminal trial that if an accused is not in attendance, if an accused has failed to produce a medical certificate, and in this instance, counsel for Mr. Zuma was notified in advance in the middle of January that this document or that sound evidence is required to justify his absence from court, and without that evidence, this court cannot do anything else but issue a warrant of arrest. However, in doing so, the court takes into account that Mr. Zuma would be an active participant in how the warrant of arrest is addressed going forward. His medical condition may be such that his participation might be impaired. Now, the order that I will grant will be one that will not bar the parties from putting forward or exchanging information or engaging with each other should they find medical evidence or information to the satisfaction of the prosecution that Mr. Zuma is unwell, and that what his needs would be when the trial resumes. Those conversations can continue, notwithstanding the order I make. Finally, it is not only Mr. Zuma who is entitled to a speedy trial, it is accused 2 who also has that right. And as Mr. Mancha pointed out, the rights of accused are well stated in the Constitution, and no one accused should be preferred over the other. In granting the orders that I do, and particular in making and issuing the warrant of arrest, I do nothing more than what the law requires me to do in the circumstances. There is one other issue that needs to be dealt with, and that is the substitution of Mr. Duran, let me get his name, full name, Mr. Pierre-Marie Durand, on behalf of accused, as a representative of accused 2. The order that I make, therefore, is the following. Mr. Pierre-Marie Durand is substituted as the representative of accused 2, Taule South Africa Pty Limited. Number 2. A warrant of arrest for accused 1, Mr. Zuma, is issued but stayed until 6 May 2020, the date on which this matter will resume. 3, this matter is adjourned to the 6th of May 2020. Thank you. Let's take a short adjournment so that we can reconstitute the court. Just to clarify that the adjournment is to this court.